reasonably audible? There's some way, Trevor tells me, that we can turn it up if we have to, and I'm not quite sure how we're going to do that. We're waiting for one of the speakers, but it's the speaker who's going to speak second or third, depending on whether you consider me one of the speakers or not. I'm moderating this event, and I want to thank everybody for coming and keep the door open, and perhaps more folks will show up, and that'll be just great. Attorney Byrne has a handout. Oh, here comes Jeanne right now, and which has been passed around, and I think Attorney Messick may have some handouts as well. In any event, so again, thank you for coming. This is the second of a series of extended second-hour programs regarding thoughts and questions for the elder passage. This congregation for a number of years has thought of looking at life's journey. One of the ways of looking at life's journey is in a series of passages, the passage from childhood to adulthood, the middle passage, and what we now call the elder passage. There are some folks, perhaps some folks in this room, who consider themselves to be at the beginning, near the beginning of the elder passage, and have loved ones, friends, and so on, who are also at the other end of the elder passage. Let's see, and I want to, first of all, thank both Linda Michael and Susie Dutcher for arranging this event this morning. With us this morning are two local attorneys, in addition to myself, who for several years have concentrated their practices and in areas to assist folks in planning for times of disability and the approach at the end of life. To my right is Elizabeth Byrne, who has been an attorney for 30 years, practices with the firm of several names: Farrow, Ginty, Sheely, Bacalet, and Marino, PC, offices on Broad Street in Middletown, and also offices in Clinton. Attorney Byrne's areas of concentration have been wills, trusts, elder law, and probate. She is a corporator of Middlesex Hospital and a member of its ethics committee. Liz has published articles on Medicare, Medicaid, and veterans benefits, and how to select a nursing home, among other topics. Attorney Jeanne Messick has been a lawyer for 34 years, practices with the firm of DiZallo, Pickett & Allen, with offices on Broad Street in Middletown, and also in Old Saybrook. Jeanne is also a corporator of Middlesex Hospital and a member of several professional organizations in the area of elder law. This presentation, let me also say, I'm Attorney John Shaw. I have practiced in Middletown for 42 years. My office is not on Broad Street, but on Main Street. And I've also practiced in the area of probate and estate administration and wills, powers of attorney, and that sort of thing. This presentation will introduce for discussion many of the legal matters which we recommend to be considered during the period of one's elder passage. While one major concern during the elder passage may certainly be planning for the distribution of one's stuff following the end of that passage, such matters of estate planning as estate planning, wills, various kinds of trusts, strategies for reducing or escaping estate taxes will be left for another occasion. Let me begin with just a couple of basics, things that maybe most of you already know before I turn it over to Attorney Byrne for her presentation. A couple of important, very important documents to have during one's elder passage. First of all is a durable power of attorney. Durable power of attorney is a document which authorizes someone else in its simplest terms, to sign your name to things. You are the principal. The person to whom you give that authority is your agent. There are various forms for durable power of attorney. Durable, the word durable, refers to the fact that that particular, if it's a durable power of attorney, it means that the agent, the person to whom you give the authority to sign your name to most everything, that authority extends even after you yourself are no longer competent to make decisions for yourself or to specifically authorize the agent to do or not to do something on your behalf. So it's durable through the period of your incapacity. It is a very powerful document. You don't want to give a power of attorney to someone unless you absolutely trust that person to act in your interests. But it is a useful document. There are times when you yourself may not be aware or capable of, let's say, paying your bills, signing your checks, any kind of business transaction, even if it's a temporary disability. You're temporarily laid up, temporarily in a nursing home, and you need someone else to help you with those kinds of matters. A power of attorney, a durable power of attorney, can be revoked at any time as long as the principal, you, are competent and capable to make the decision to revoke it. There are several different forms for durable power of attorney. The most common one that we see is the Connecticut short form durable power of attorney, basically 2 pages, widely recognized within the state of Connecticut. Most banks and business offices know what it looks like and will be honored for those sort of local kinds of transactions. I also have recommended a longer form durable power of attorney, which also includes things that, powers and authorities that would be recognized by financial institutions out of state, for example, which are not so familiar with the Connecticut form and sometimes give the agents a little bit of difficulty in using those. Sometimes, if you have a financial advisor, financial investments in any kind of, Fidelity, T. Rowe Price, Raymond James, that sort of thing, those companies very often have their own durable power of attorney forms that they prefer, and you would want to ask them about those. The IRS, Social Security, Veterans Administration have their own power of attorney forms and are probably less likely, if not completely unlikely, to recognize the Connecticut form durable power of attorney. So if you feel that your agent will need to deal on your behalf with any of those government bodies, you will need to execute their form. My understanding is that Social Security Administration is quite strict, and if you are going to want an agent to deal with Social Security on your behalf or in your absence, you will probably need to bring the agent with you to the Social Security office so that they can know who it is that you're giving that power to. I don't personally recommend having multiple agents on one power of attorney document, although it is possible and is authorized under Connecticut law to do that, either to act together or to act one after the other. If the first one can't, then the second one has the power. Only because I just think that creates can create difficulties and bureaucratic difficulties and so on that would slow down the process of being able to use it, but other attorneys, I know, feel differently about that. Finally, for older persons in the elder passage, it would invite people giving a power of attorney, let's say, to your spouse, which is very common, to also consider a backup, a durable power of attorney to someone else, just in case the spouse himself or herself may have issues of competence themselves when it comes time to use the power of attorney. Healthcare instruction documents includes 4 parts. It's also in a Connecticut form. The language in the healthcare instructions is pretty much dictated by state statute, which is so that medical professionals will be covered and have a safe harbor, as lawyers sometimes say, for to recognize the matters in healthcare instructions. As I said, 4 parts. First part is what most people know of as a living will, which expresses your intentions under certain circumstances where keeping you alive under circumstances where there is no real hope of recovery would express what your intentions are under those circumstances. The second part is the appointment of a healthcare agent or a proxy, which would be someone to make medical decisions for you under circumstances where you cannot make them for yourself or you cannot communicate them. You would want that to be a person who really knows what your feelings are about different kinds of medical decisions that might be needed to be made. The third part is the appointment of a conservator of your person, which is in the event that you cannot make the decision to appoint a conservator, and you need a conservator to decide where you will live, whether you will go home, whether you will be in a nursing home, what kind of care, what kind of physical care you will have. And part 4 of the healthcare instructions is a designation of anatomical gift, which is pretty much the same, I think, as the kinds of check-off that you can have on your driver's license. And I find very often people who have done that with their driver's license prefer not also to include it on their healthcare instructions. Other people want those instructions to be in both places. Upon admission to a hospital for any kind of a procedure, you may be asked if you have healthcare instructions, and if not, the hospital may offer a form for you to sign if you wish to do so of these kinds of healthcare instructions. Often I find these hospital forms are specific to your particular admission to that particular hospital and may not be generally applicable in other times and other places. So a general form of healthcare instructions is usually a good thing to have. Finally, I tend to recommend to my clients that one of your copies of your healthcare instructions be taken with you when you travel, in case you end up or need to be in a hospital or a medical facility in a distant state where they don't know you perhaps as well as they do locally in Middlesex Hospital or where your primary care physician is. Those are a couple of quick things about durable powers of attorney and healthcare instructions under Connecticut law. And we will take questions and discussion after all 3 presentations have been made. And we hope to leave plenty of time for that. And so now I'll turn the microphone to Attorney Byrne.
not about estate planning, not about disability planning generally, but about the worst case scenario, which is that somebody ends up in a nursing home. So can everybody hear me? No? Yes? Can everybody hear me now? Okay, very good. So I think I'll start by just telling you, first of all, what's in the handout that I dropped off at everybody's seat. So first of all, what I have is a publication from the Department of Social Services. They have a pretty good website, dss.gov, I guess it is, ctdss.gov. But they have a number of publications and forums that deal with Medicaid, and there's one good publication which I have included here, and it's 15 pages long that talks about all the different Medicaid, Title 19, SBC, that's those names for that program, in terms of definitions, what you could expect, and it's pretty well done. But the only problem with it, like a lot of things you see, is it has not been updated. So what I've done is I've gone into the 2013 form and I updated it with the 2015 numbers in terms of values of assets, value of income, home equity, allowances, and things like that. So for the first few pages here, up to page, let's see what page. I guess up to page 20, we have the Department of Social Services publication. Then on page 21, what I did was I took a fact scenario dealing with a married couple's assets. So you could see what could happen if one of them ended up in a nursing home. So that's on page 21, we're going to get to that. On page 22, I did something similar but dealing with their income, the married couple's income. And then on page 23, 24, 25, I have information, and page 26 and page 27, information about transfers of assets, in other words, gifts. Everybody's heard this business about a 5-year look back, a 3-year look back. We're going to talk about that and how it impacts the Medicaid application. On page 28, I included a Fox News article about a woman who decided to send her, to spend her elder passage, literally on a passage. She has decided to live on a cruise ship. And it's very interesting because it's $13,600 a month for her to live on this lovely cruise ship, and she's done it for 7 or 8 years. And that's just about what a nursing home runs around here, $13,000 to $14,000 a month. And then my bio is on the last page, okay? So are you still hearing me okay? Yeah, okay. So we're going to talk, as I said, about Medicaid for long-term care. There is Medicaid available for other types of care, for home care, and Attorney Messick is going to talk about those other options. Before the program began, Attorney Shaw and I decided I should go next in this discussion because this is such a bad topic. You know, this is the worst case scenario that somebody ends up in a nursing home, and we decided Attorney Messick can tell you what the positives are and what the alternatives are, and then you'll leave feeling a little bit more, positive about the subject. So it does happen that we have somebody end up in a nursing home, and that is not at all what anybody intended. But it does occur, it occurs pretty frequently. And I just want to start by differentiating between Medicare and Medicaid. So when somebody, an older person usually slips and falls at home, they break something, they end up being ambulanced to the hospital, they enter through the emergency room, they have x-rays, they determine they've got a broken hip, then they have surgery to reset it or replace it or whatever, and then they go to a nursing home. That is all covered by Medicare, and sometimes there's a supplemental medical insurance as well. So Medicare has more to do about age and disability. Medicaid, on the other hand, is a means-tested program. So different than Medicare. Medicare, Warren Buffett qualifies for Medicare, all right? So Medicaid comes up more often than not when somebody's been in the nursing home for rehab, and now it's time for them to leave. or it's time for Medicare to cut off. What we have heard for the longest time is that you've got 100 days in a skilled nursing facility after you were admitted to a hospital for 3 midnights. And what we've seen over time is very few people get 100 days of coverage. These days, it seems to be more of 21 days, maybe even fewer days than that. Then the nursing home will tell the family that within 24 hours, Medicare coverage is ending, and what's the plan for going forward. So 22 days after somebody's entered the nursing home, or when it's time for the Medicare program to cut off, the person may not be ready to go home. It may be that they don't need any more therapy, they don't need any more rehab. It may be that they didn't do well with rehab because of dementia or something like that. Or it may be that it just makes sense then for a family to keep their loved one in the facility, in the nursing home. So question, how are we paying for it? If nursing homes around here run, the state of Connecticut says they run at $12,000 a month across the state. Here in Middletown, it's about $13,000 to $14,000 a month. Who's got that kind of money? So we're either paying for it with private dollars, we're writing out a check to pay for it. We're using long-term care insurance if we have long-term care insurance. And if we don't have long-term care insurance, we're looking at some other way, such as Title 19, otherwise known as Medicaid, also now known as Husky C. So the nursing homes quite often ask before the loved one even leaves the hospital, they ask the family, how are you going to pay? And payment may be initially Medicare, but then the question is, he's ill, she's ill, chances are he's staying or she's staying, how are you going to pay when Medicare ends? So they're starting the family thinking about payment and starting them to think about Medicaid, because many, many, many people do not have those resources to pay $13,000 a month to a nursing home. And if you have a spouse living at home thinking, how am I paying for my rent, or how am I paying for my real estate taxes, my food, and pay $13,000 for him or her in the nursing home, it becomes a real issue. So that's when we begin to think about Medicaid, because Medicaid, if you qualify, will pay for that long-term care expense. So here you are with a loved one in the hospital being discharged to a nursing home. You've got the stress of that one being out of the house and being very ill, and now you have to start thinking about finances. How are you going to manage that expense? And that is when you really need to consult an elder law attorney. Because more often than not, and I think Attorney Messick would attest to this, more often than not, when couples or family members come in to meet with us, they find that the protections in the law, especially for a community spouse, the spouse who's at home, are sufficient to keep care of the spouse who's at home and still qualify for Medicaid for the one who's in the nursing home. So more often than not, they actually leave the office feeling better, that things are going to be okay. And with my illustrations that we're going to get to with these different asset and income numbers, what you see in both of these cases is the spouse at home is actually fixed in a pretty good position. And that's largely due to something called the Spousal Impoverishment Act that Congress passed a few years ago. Because before that was passed, what would occur is one spouse would go into the nursing home and the other spouse would use up all their resources trying to care for that one who's in the nursing home or pay for the care for the one who's in the nursing home. Before you knew it, they were both on welfare. And Congress put the foot down and said, no, we've got to do something about this. So with that federal law, we now have protections for the well spouse, the community spouse who's living at home, both in terms of the house that they own and they live in, some of the liquid assets that they have, and all of their income, enough to cover what we call shelter expenses. So when Attorney Messick and I, both of us being elder law attorneys, sit down with our clients, what we're looking at is assets, we're looking at income, we're looking at medical insurance, we're looking at health situation, We're looking at those disability planning documents that Attorney Shaw mentioned. We're looking at powers of attorney to make sure that we have enough authority to move assets around as we're allowed to do by law. So with Medicaid, if we had a situation where it was one person not married, who is in the hospital, moving to the nursing home, or now staying in the nursing home, we do not have as many protections available to that person. Essentially, their assets, if they're going to stay in the nursing home, their assets need to be spent down to $1,600. So assets are savings. It's not Social Security, it's not pension, it's savings. So whether it's retirement account, whether it's life insurance with cash value, whether it's money in the bank, whether it's CDs shared with somebody else, all of those assets are identified and they need to be spent down to $1,600. And that person is not going to be found eligible for Medicaid until we can prove that their assets have been reduced to $1,600 and that they did not give their assets away in order to reduce them to $1,600. So that's the part 2 of this means testing. So they're looking at assets and they're looking at what you've done with your money in the last 5 years. So we now have a 5-year look back. When we fill out our 21-page Medicaid application and we include our 5 years of bank records and life insurance records and financial account records, the caseworker that we're handing this all to in the Department of Social Services is looking to see whether money went missing from the account. What were gifts made? And it doesn't really matter what the nature of the gift was, whether it was a gift to a church for an organ, whether it was a gift to the American Red Cross, whether it was a gift to a grandchild for tuition. What the state is looking at is whether you had money that you could have used to pay for your nursing home bill, and now you don't because you gave it away. So across the board, 5 years of look back, looking for transactions, looking for gifts. So when we say we have a 5-year look back, that means we are looking cumulatively for each of the 5 years. 5 years ago, you made a gift of $5,000. 4 years ago, you made a gift of $2,500. They add up all these gifts. They look at the total amount of gifts made, and then they divide it by the average monthly nursing home cost in the state of Connecticut, which they say is approximately $12,000. So if you make $24,000 of gifts in 5 years, $24,000 divided by the average monthly nursing home cost of $12,000 equals 2. And what that is 2 months of ineligibility for state-paid care in the nursing home. And that begins when the person is in the nursing home and broke. Next 2 months they can't pay. The state of Connecticut is unwilling to pay. And the nursing home is looking for the family, the transferee, the person who received the gift, to pay. It's a real problem. So it has really put a damper on gifting. And what we've seen with the economy in the last few years is people have had legitimate reasons to move money. They've moved money to help their son or daughter save the house. They were just about to go into foreclosure. Real valid reasons. They've helped with groceries. They've helped with tuition when the children couldn't do it because children lost their jobs. But the state doesn't really care what your rationale was. They consider it to be presumptively a planned gift to reduce down your assets so that you will qualify for state aid earlier. So we have, and this is in the materials, we have some penalties for those types of gifts. And the first penalty is the state won't pay. So they just send a letter and they say, we're not going to pay for January for February, or February for March, whatever the time period is. The nursing home is getting that letter the same time you're getting that letter, and the nursing home is saying, how are you paying? I've had some nursing homes identify that gifts were made before the person goes into the nursing home, and the nursing home has either refused to accept the person who made the gifts or required the family members to guarantee the payment, or else they won't admit them to the nursing home. So it's a serious business. So We've got the issue of the state refusing to pay, and then we have the issue of the nursing home, and this is on one of the pages. Let me just tell you what page it is. Page 27 is actually one page from the local nursing home's admission application. And what we see is being required now is that whoever it is who's signing mom or dad into the nursing home is being asked to sign a resident agreement. Oftentimes, mom and dad can't sign for themselves because of dementia or whatever. And the nursing home business office is asking the family to sign. So they say right out front, we're not saying that the person who signs this document is going to be personally liable on this contract. But most of them have one or two pages where they talk about the requirements for the person who is signing this agreement on behalf of the parent and who may have control of the money and who may have actually received money from the parents. So if in that case you have someone in charge of the money and having received a gift in those 5 years in advance of the Medicaid application, the nursing homes are saying we consider you to be personally liable for the amount of that gift. So it's a concern both that the state won't cover and a concern that the nursing homes have people signing these resident agreements. And the resident agreements are contracts between whoever is signing and the nursing home. And in here, always, there's some provision about personal liability in certain cases. Then we also have a new state law that says that the state can actually put a lien down on property that is the subject of a dispute between, for example, a nursing home or the state of Connecticut and a person who's applying for Medicaid. So we've had situations where somebody applies for Medicaid, there's a denial, the family is feuding about who's responsible on the nursing home bill. Next thing you know, the state has put a lien on the property. So they consider it to be property that is in dispute. You know, the ownership of it is in dispute. So we've got a bunch of concerns when it comes to transfers. So when we are applying for Medicaid, Title 19, again, means tested, a single person's assets need to be reduced down to $1,600. And that would include the house if the person is not returning to the house. So if you own a house, let's say you own a house and you're cash poor. And this happens obviously quite a bit. You have very little money in the bank, you own a house, you're in a nursing home, and you can't possibly afford to come up with $13,000. In that case, the state will, if you haven't made a gift, the state will allow the Medicaid eligibility once the cash is reduced to $1,600, and they require that the house be put on the market, be listed for sale. As long as there's no spouse in the house, there's no sibling in the house, there's no disabled or minor child in the house. Okay, so we've got all sorts of rules to qualify for Medicaid. When it comes to spouses, though, we've got some benefits. As I said, we have the Spousal Impoverishment Act. So with the Spousal Impoverishment Act, not all of the resources of the married couple need to be spent down in order for one of them to qualify for Medicaid in a nursing home. And what we see quite often is that when one spouse is in the hospital or one spouse has just entered the nursing home, the well spouse, the community spouse, is in the office saying, what do we do now? And what we do is we look at their assets, and then separately we look at their income. But I'm going to ask you to look at page 21 of the handout. Because on page 21, what I have is just an illustration of what could occur in terms of Medicaid. And this assumes no gifts were made in the last 5 years. But in this case, we have a house jointly owned, $350,000 of value. There's a mortgage of $50,000. There are jointly owned bank accounts. The husband has an IRA. There are 2 cars. There's a MetLife insurance policy, $12,500 cash value. There's stuff in the house. The wife gets ill, ends up in the nursing home. She's going to stay there. Maybe she has dementia. Maybe this is a better situation for her to stay in the nursing home. In that case, what an elder law attorney would advise is that we consider some of the assets at risk, some of the assets not at risk. When we look at this particular scenario, and everybody's situation is different, when we look at this one, we would say we can use a power of attorney with gifting authority to transfer the house into the name of the well spouse. So the well spouse would live there and would occupy the house. And the house would be titled in that person's name only. We'd use that power of attorney to make that happen. The well spouse could keep one car. Prepaid funeral contracts for both of them. Life insurance with no cash value, like if you have a death benefit from the state of Connecticut, for example, that would be untouched. The well spouse, in this case, would keep his own income, and he'd keep all the stuff in the house. You know, when you go on Medicaid, the state is not coming in and taking your stuff, your jewelry, your possessions, your furniture. That does not happen. So don't worry about that unless you have a Monet or something like that. So in this case, all the rest of the assets that are not protected would include the jointly owned bank accounts, $220,000, his IRA, $120,000. One car is not protected because we protect one car but not two cars. We protect one house, not multiple of houses. And the MetLife insurance policy also would not be protected. So people are aghast at the idea that they have to liquidate their life insurance, and they do because it's liquidated, the cash is used to pay the prepaid funeral. So you still have the same benefit, the same idea that the money's put aside for funeral, but it's not happening with the old life insurance policy, it's happening with cash. So the money, in this scenario, we have a total dollar amount of $359,000. Of the $359,000 here, $119,220, this is a federal formula, would be set aside for the spouse who's living at home. So the spouse at home has the house, the car, the prepaid funeral, the death benefit, life insurance, and $119,220. And that's the maximum under our federal law right now. And let's see what else. Okay, so what we end up with is cash of $119 being set aside for the well spouse. The sick spouse can have no more than $1,600 in order to qualify for Medicaid. And of that total, $238,000 have to be spent down. They do not have to be spent down on the nursing home. And I found it interesting when I was looking at the DSS publication, they actually say that in this publication. The money needs to be spent, it does not need to be spent in the nursing home, and it cannot be gifted. So if you take that $200,000, you gift it away, you're going to end up with a number of months of ineligibility for that person who's now sitting in the nursing home. So that isn't, ideal. But instead, for this particular couple, and every couple is different, what we would probably suggest is we would take that $238,000, we'd pay off the mortgage of $50,000. We would annuitize the husband's IRA of $120,000, and that would become a monthly check, IRA check, coming in on a monthly basis. We would purchase a prepaid funeral, we'd pay the estimated taxes from all this annuitizations and liquidation, the MetLife, there would be some income tax. We'd pay off any credit card debt that the couple might have. Might get a new car, we can do that. And we might use extra money to purchase a Medicaid qualifying annuity. And I know that sounds like a jumble, but we have a new option, and that is to take extra cash to buy a particular type of annuity for the well spouse, to pay to the well spouse on a monthly basis for approximately 5 years. And that serves to increase the income that the spouse would have at home, the well spouse would have at home. So this, in this couple's case, would be the worst case scenario. And when you look at the numbers, we've moved all the assets around. We've manipulated all the assets. But we end up with the sick spouse on Medicaid. We end up with the well spouse having preserved the assets and still paid for the funeral and paid off debt. So that isn't a bad result, really. Worst case scenario, somebody, a loved one being in a nursing home, but not a worst case scenario financially. So, and then I'm kind of running short on time here, but In terms of income, that's the next page that I have in the handout, that's page 22. When we apply for Medicaid, the state looks at so many things in the 21 pages of application, but one thing they look at is what is the sick spouse's income, because that may go all to the nursing home. What is the well spouse's income, and what are the expenses for the well spouse to stay home? Because they want to make sure, under the Spousal Impoverishment Act, they want to make sure that the well spouse has enough income to pay for mortgage, real estate taxes, homeowners insurance, condo fees, rent. And then there's an additional amount of just plain old living expenses. So in this case, in this scenario, this couple has a total monthly cost of $2,930. And the well spouse in this case has only $22.99 coming in every month. And the result is that the state would allow for $631, the difference between the two numbers, $631 from the sick spouse to be applied to the well spouse to help cover the household bills. The balance then would go to the nursing home. So that's the type of math work that's done with the Medicaid application. So again, it's a means-tested program, and they're looking at assets. They will take a look at income, but you know, the big issue is whether you've given money away in those 5 years. And if you have, I say money, assets, could be the house, could be cash, there are concerns. There are some exemptions from penalty. For example, if you give your house to your spouse, or you give your house to a caregiving child who's lived in the house for 2 years, or a sibling who owns a part interest in the house who also lives there, or to a disabled child. So there are some exemptions from the heavy penalties. But that's the type of thing that you'd review with an elder law attorney when you have that meeting. So, and I'm available to answer any questions at the end, okay?
Well, you can get my things afterwards. It's good that I'm moving through these things anyway. Okay, so I get to cover what we call the good news, and that is, in many cases, it's not necessary to keep someone in a long-term care institution. There may be ways to keep that person home. So in the materials I brought, you'll see that there's some kind of a story about what happens if the person who has maybe rehabbed in the nursing home is ready to come home, how we can get some services brought in, and in many cases get some help from the state to pay for those services, so that we don't have anyone unnecessarily institutionalized. So what happens is, for the most part, the programs I'm talking about, you have to be over the age of 65 in order to qualify. So we're not really talking about disabled adults. There may also be programs for them as well. You know, that person doesn't necessarily need 24/7 care, or perhaps they do, but family members are willing to pitch in and cover some of the hours, but there is some need for some either home health aides, homemakers, maybe visiting nurses occasionally. So Connecticut has what's called the Connecticut Home Care Program for Elders. There are 3 levels of care in general, and the 3 levels of care kind of look at how, what kind of activities of daily living the applicant is not able to do. So one of the programs is funded by the state. It's called CHCPE, that's Connecticut Home Care Program for Elders, levels 1 and 2. That will allow a certain dollar amount of care per month. And generally, the person has to have some difficulties with performing activities of daily living. could be 1 or 2 for the first category, 2 or 3 for category 2. And we're talking about bathing, dressing, feeding, that kind of thing, toileting, transferring. So the category 1 and 2 has only an asset limit, meaning that the state is going to look at the assets of the individual who's applying. And in case of a couple where there's not 2 people on the program, but it is a husband and wife scenario, there is an asset limit, a larger asset limit for assets in the names of the couple. So we have to look at that. As far as income is concerned for this program, the income is looked at. There may be cost sharing, however, if the income of the individual is over a certain amount. So the state, kind of what you do to apply for these programs is you file a form or you call the state alternate care unit, and they contract with agencies for each region. I believe